My Lords, just finishing off on the position of Mr. Miller and Gazprom, which we were discussing before the short adjournment. Now, obviously, it's reasonable to suppose that someone in the position of Mr. Miller, the CEO of a very significant company, does have personal wealth. And on our construction of the regulations, it's possible for the government to list him as a designated person and thereby freeze his personal wealth without also freezing all the assets of Gazprom, the company. But of course, that's not actually possible on the appellant's construction of the regulations, because the automatic consequence of listing Mr. Miller, the CEO, on their case is to freeze all the assets of Gazprom on the basis of Regulation 7.4 control, so possibly also 7.2 control. So on their construction, the government cannot freeze his personal wealth without also freezing the assets of Gazprom, which you might think is a surprising result, which does not apply on our construction. And really the same point applies, that across the board, when one thinks of state officials and Vladimir Putin himself, as my learned friend said, there's a lot of speculation in the press about the personal wealth that Vladimir Putin may have built up whilst he has been president of Russia. And on our construction, it's possible to target and freeze that kind of personal wealth of state officials without also, by the back door, sanctioning the entire economy. And the same applies, of course, to Miss Nabulina. As we'll see in a moment, the government has actually said in terms, when it listed her, it does not regard her as controlling the Russian Central Bank for the purposes of Regulation 7. It's actually issued a public statement to that effect, which we'll see. Now, another point, the next point really, is another point to do with the consequences of the appellants being right on their construction of control. Because, as you've seen, there's this quite carefully crafted scheme of asset freezing, then further and different sanctions like the banking sanctions and financial services and trade sanctions. And if they're right, that whole scheme is thrown into a kind of hopeless confusion. And there are lots of examples that could be given about that, but let's take a very simple one. We've seen under Regulation 17 that it's a crime to give a loan of more than 30 days to a person connected with Russia. So any Russian company, you can't give them a loan if the maturity is over 30 days. Now imagine you're approached by a Russian company that asks for a short-term working capital loan of 20 days. One would look at regulation, and it's not a designated company. One would look at Regulation 17 and say, well, that's possible, because what's prohibited are loans to persons connected with Russia over 30 days, and this loan is not over 30 days. Now, if they're right, that company is indirectly subject to an asset freeze such that you can't grant it a loan at all of any kind, even if it's 2 days. So it's just an example of how this...
That's just to restate the question, isn't it? Because those are cumulative requirements. Regulation 12 is going to apply to those anyway. That doesn't matter whether it's 1 day or 30 days or 6 years. So one's got to apply the control test for Regulation 12 purposes as much as for other purposes.
Yes, but you've got on our construction quite a carefully structured scheme that seems to work. Whereas on theirs, given that any Russian company is subject to a total asset freeze, all these distinctions about 30 day, under 30 seem to be irrelevant, in fact. Because you can't...
There's a difference between any person connected with Russia and a designated person or a person controlled by a designated person. The former comes within Regulation 12 and the kind of loans we're talking about.
Yes.
the wider class is caught by the wider loan provision.
Yes, but
So
my
see
point is,
how that helps you.
my point is that on their construction, every Russian company is indirectly subject to Regulation 12, so you can't grant any loan to any Russian company. So the specific provision that in 17 is made irrelevant. The 17 addresses, can you grant a loan to a Russian company? It says, yes, you can if it's under 30 days, but on their construction, you can't actually do that without committing the crime anyway, because you're advancing funds to a controlled person, even if it's a 10-day loan. That's the point. It's just an example of how you seem to have this scheme.
It's the Putin point again, the fact that Putin
Yes.
has been designated has this effect.
Yes, yes. One also has the continuing designation of entities after President Putin was designated, which appears to make no sense if they're correct. Because if the effect of designating Putin was as they say, there'd be no point in designating further governmental entities, for example. So that would at least show the government has misunderstood in quite a fundamental way the effect of its own legislation. And the judge gave a couple of examples of subsequent designation at paragraph 210 at core bundle page 186. So there's been continuing designation of state entities after Vladimir Putin was designated. They give an example in their skeleton at footnote, the appellants give an example at footnote 31 on page 45 about a entity that has been designated in a way that they say supports their reading of this. But that was a situation where a particular individual, Mr. Malofiev, was himself designated very early on, indeed in July 2014, and then much later, an organisation called the All Russian Public Organisation has been actually been put on the list, designated, which on the basis that it's controlled by him, which doesn't appear to support their case, it appears to support ours. I mentioned that point, it wasn't addressed. Now the government press release I mentioned earlier, it's actually quoted in the judgment at paragraph 221, a core bundle page 189. So this was when in September last year, Miss Nabulina was added to the list of designated persons. And this is where the government issued a press release explaining that, and you see it 221, it quotes that press release. And the second paragraph is the UK government does not consider that Elvina Nabulina owns or controls the central bank of the Russian Federation for the purposes of Regulation 7 of the Russian sanctions regulations. So that's only explicable on the basis that they are essentially operating on the basis that we are operating on, that the intention and effect of designating her was to freeze her personal assets and stop anyone doing personal business with her, so you can't sell her a flat or anything like that, but not to indirectly subject the Central Bank of Russia to sanctions by the back door in circumstances when it's not specifically listed as a designated entity. And just to, I mean, obviously no one says that that is binding on this court. It's obviously open to you to find that that is a total misunderstanding, in effect, by the government of its own legislation. But it is the very ministry that actually drafted the regulations. These are secondary legislation created by the Foreign Office. Now there's another point in relation to that at Judgment 243, which I just want to pick up briefly. Because there's some points here about the OFSI guidance. And again, the judge quotes the guidance. And it's really the last paragraph of the quote I just wanted to pick up over the page on page 194. Because one of the other things that's also said publicly by OFSI in this case, which is part of the Treasury, is that the UK government will look to designate owned or controlled entities, individuals, in their own right where possible. So that's the stated position of OFSI. And one can see the sense of that, why that is of assistance to people trying to regulate their affairs and their business by reference to sanctions. And of course, things like Gazprom, the Russian central bank, one can only really infer from that there must be a deliberate decision not to designate them. So, yes, and an allied point to that, remember earlier I made submissions about how only the designated person can bring a court challenge to get themselves taken off the list and a controlled person can't. Under the regulations, the Secretary of State actually has an obligation to notify a person designated and to publicise the reasons for it and the fact of designation. That's Regulation 8, page 912. So it links with the point I just made, that under the secondary legislation, the regulations, the executive actually has to notify the person, publicise the fact they have been designated and the reasons for that. And that obviously then is a platform. If that person, because reasons have been given, that person is able to look at the reasons and then potentially challenge whether they are an appropriate person to be designated. Now, I've dealt with the distinction between state and employment, and as I've said, we don't advocate the judge's distinction, so I've dealt with that. So it's got to sweep up now some other points. Reference was made by my learned friend to the HTTS case. I'm not going to go to it in detail, but as I submitted below, there's a very simple fact that suggests this case is not particularly illuminating, because it was about whether one company in fact controlled another company. So it doesn't have that same issue of personal versus employment, state official capacity. It's just an issue about whether a company controlled another company. So that's not going to illuminate the point we're on very much. Reference was also made to the EU guidance. I think in a strict sense, really what this is an opinion issued by the European Commission. So it's an opinion issued by the European Executive about certain matters. So not therefore part of European law as such, but an opinion issued by the Executive. And really in my submission, that guidance is not illuminating in any way, because it simply says ultimately, in the passages you've already seen, that it's for the national competent authority to determine whether, as a matter of fact, there is the requisite control. It doesn't provide any analysis that's illuminating or useful in this case, and certainly isn't a part of European law in the true sense. It's merely an opinion. They can't point to any clear authority under European law that supports the case they're making here. I mean, obviously, European regulations have a concept of control and apply to controlled persons, but there's no definition of control in the same way that we have in Regulation 7. That's something that's a creation of the regulations rather than being transposed from the regulations. And there is, and for example, President Putin, or Vladimir Putin, is sanctioned under the EU regulations. And there's no material to suggest the effect of that is to sanction the entire Russian economy by the back door. all they're able to point to in terms of actual law are a couple of cases, one of which was Syriatel, which is a case that was relied on in first instance. And really, it's just a question of what the facts of the case were that really is quite interesting, because you can get that very clearly from the first instance judgment at tab 99 of the authorities on page 4785. And this was a, sorry, I'll just give a moment. Just to really give you this is where you see most clearly in the first instance judgment what the actual facts of the case were, and in particular at paragraphs 92 to 95. And you see really it's just a case of classic control, ownership and control in the normal sense. Syriatel was trying to get itself delisted. A particular listed individual was the managing director of Ramac and owned 99% of the shares, and was CEO also of another company, and Ramac and that other company together owned 67% of Syriatel's shares. So that was the basis, or one of the bases on which it was controlled by him. So it doesn't really give, I mean, it's as thin as that in terms of giving any analysis or guidance that's illuminating in this case. You really don't get anything like that from Syriatel, because it's a fairly standard case of control through control of the majority of the shares. The only other case that was mentioned was a case called Al-Dalumi, which was at tab 24. It's very difficult to see exactly how this assists anything. It's a decision of the European Court of Human Rights, so actually interpreting, applying human rights law rather than sanctions law, and it's a delisting type situation where someone who was the head of finance for the Iraqi Secret Service under Saddam Hussein was making a claim along with a Panamanian company in relation to the freezing and confiscation of their assets in Switzerland. And the issue in the case, a very long, complicated judgment, was whether what had happened in Switzerland was consistent with Article 6, whether he'd had fair access to the courts and fair ability to challenge the freezing and confiscation of his assets. So it's just not really on point at all. It's not entirely clear what point they were making in relation to it. Now, can I just wrap up by saying one thing? I mean, your lordships may think, well, why does any of this matter? Because of course the judgment, the judge said, well, it doesn't matter. It's not on the critical path as such, and therefore dealt with it briefly. Just to give a bit of context to that. Our case is that NBT is the only claimant that has a claim, because our case is that long before Bank Equity was designated, all of the rights of claim were transferred as a matter of Russian law from Bank Equity to NBT. That's our case. So only NBT has a claim, and Equity is a claimant in case we're wrong about that, essentially. That is met, the transfer allegation is met with a non-admission rather than a positive case that it was ineffective in some way. And of course, if we're right, NBT is the only claimant and it's not controlled. If we're right on both of those things, then it's just in the position of any other litigant before this court. We can have a judgment entered and be paid and enforce that judgment in every way that a normal litigant could have, because it's simply not ruled by the sanctions at all. So this point has a lingering importance in the case for that reason, if I can put it like that. And it's a matter for your lordships as to how to proceed. we would say there's an overriding public interest or importance in clarity in this area of the law, given the consequences, and therefore of a judgment dealing with it. Although that's obviously a matter for the court, but I'm sure you see the fuss of that. So, unless there's anything else, those are my submissions on the control issue.
Thank you very much, Mr. Davis.
Lords, can I give your Lords a very quick roadmap at the outset of the topics I'm going to seek to address in the reply, nearly all of which concern ground one. First, I'm going to identify what we submit as an overarching problem in my learned friend's submissions in relation to ground one. Secondly, I'm going to address my learned friend's submissions about whether the entry of a money judgment is unlawful under Regulation 12. And third, I'm going to address the question of whether the court is a person. Fourth, I'm going to address whether the principle of legality is engaged. Fifth, I'm going to address my learned friend's submissions about the EU regulation Article 7.2c, and in that context, Section 44 of SAMLA and the R&R case. And then sixth, I'm going to address the workaround point, if I can. I at the moment, am not proposing, and I don't think I will have time in any event to say anything about control, which is anything I need to reply to on that. So, can I turn to the first topic then, my Lords, and that, as I say, concerns what we respectfully suggest is an overarching problem with my learned friend's submissions on ground one, and it is this, a failure to distinguish between the construction of the sanctions legislation and the procedural consequences in an individual case in the light of the legislation so construed. My learned friend began his submissions on Wednesday afternoon by saying more than once that it is our case that SAMLA and the 2019 regulations mandate an immediate and indefinite stay of a civil claim. And my learned friend suggested on that footing that the question raised by ground one is whether an immediate and indefinite stay is, as in my learned friend's words, this is what he said, the lowest level of interference in the fundamental right of access to justice that is authorized by SAMLA. That is transcript A2, page 138, lines 10 to 14, again at page 139, lines 10 to 19. And that, with respect to my learned friend, is simply not correct. It is not, and has never been our case, that SAMLA mandates a stay of civil proceedings. But it is, and remains our case, that the entry of judgment is unlawful under SAMLA and the regulation. And that, of course, turns on the construction of SAMLA and the regulations. And my Lords, if we are right about that, there is obviously then a separate question whether any particular claim should be stayed. And that goes to the exercise of the court's discretion. And that question is plainly not a question of construction or interpretation at all. And my Lords, we respectfully submit that there is obviously no requirement that the court's decision to grant a stay in an individual case must be authorized by SAMLA. Neither the principle of legality nor any other principle requires that. And if at the end of this hearing, your Lordships are persuaded that the entry of judgment is unlawful, or that we are right about the licensing points, then the appeal in our respectful submission should succeed, and the case would fall to be remitted to the High Court to decide what the procedural consequences should be. And that is why, in light of your Lordship's indication, I didn't, in the event, make any submissions about whether there should be a stay or discharge of the undertakings. Can I then move on to Regulation 12, which I would respectfully submit is at the heart of this appeal. Now, my learned friend, as we understood his case, had three separate points about Regulation 12. I can just first identify them. First, he says that the court, when it enters judgment, creates a fund but does not make it available because it cannot be used in this country. Secondly, the learned friend says, as we know, that the court is not a person. Third, the learned friend says that the principle of legality dictates that there is a carve-out, as my Lord Justice Popplewell described it, at day 3, page 110, line 2, for core judicial functions. Now, so far as concerns the first of those points, we respectfully submit that it is founded upon a false premise, namely, that a fund is not made available for the purposes of Regulation 12 unless the fund can be used by the designated person once it is made available. And in response to a question from my Lord Justice Popplewell, my learned friend confirmed that is indeed his case. For your Lordship's notes, that is at day 3, page 134, lines 1 to 7. My Lords, if that is right, it would be open to someone to transfer, say, £10 million to the UK bank account of a designated person. The £10 million, it is common ground, constitutes funds, and the designated person would not be able to use it because, of course, any UK bank account that he has would be frozen. So £10 million paid, but not available for use. But it could not, we respectfully submit, be seriously suggested that the sanction regime permits anyone to gift any amount of money to a designated person merely because the gift is frozen once it is made. My Lords, what we submit that example demonstrates is that it is no part of the definition of making available that the designated person should be able to use the funds once it is made available. It is the fact that the funds are made available, that is to say, provided to the designated person, that triggers Regulation 12, not what the designated person does with them or can do with them once they are made available. And so, my Lords, if the court is a person and it enters a money judgment, we respectfully submit that it makes available a fund to the designated person, irrespective of what, if anything, the designated person can do with the judgment debt. So, my Lords, we respectfully submit that there is nothing in my learned friend's first point. Now, his second point is about whether the court is a person. I'm going to come back to that, if I may. The learned friend's third point was that there is a carve-out such that Regulation 12 does not affect the court's core judicial functions. And we respectfully submit that there are a number of problems with that. First, there is of course nothing in the language of Regulation 12 or the equivalent provisions in SAMLA, Section 3, containing a carve-out for anything, whether core judicial functions or anything else. Secondly, and following from that, this carve-out point only gets off the ground if the principle of legality is engaged. And I'll come back, if I may, to why it remains our case that it is not engaged. Thirdly, even if the principle of legality is engaged, the learned friends appear to accept that while the court is entitled to read down general words, it cannot read words into legislation. That was day 3, page 19, lines 8 to 12. And your Lordships will recall that this distinction between reading down and reading in is a point that was made by Lord Sales, then Mr. Sales, in the LQR article to which I took your Lordships. If your Lordships were to ask yourself, what particular words in Section 3.1d and Regulation 12 does my learned friend wish to read down, and read down in what way? The answer is that there are none, other than his court is not a person point, which I'll come and address separately. But my learned friend's case that core judicial functions, as he puts it, are not affected by Regulation 12 only works, we respectfully submit, if your Lordships were to read Regulation 12 as if it said that no person may make funds available to a designated person, save that judgment debts may be made available. But that, with respect, is not to read down anything. It is to read into Regulation 12 a proviso that is not there, which the principle of legality does not permit the court to do. Fourthly, the learned friend accepted, despite the principle of legality, that judgment debts constitute funds. Now, my lords, as your lordships will recall, Section 61, subparagraph 1, does not expressly say that judgment debts are funds, nor does Regulation 12. But my learned friend was nonetheless, rightly, but ultimately constrained that he had to accept that they are funds, because, of course, there is a definition of funds in Section 60, subparagraph 1, and judgment debts plainly fall within that definition because they are financial assets. My lords, one might rhetorically ask, if the principle of legality does not prevent the court from looking at the definition of funds in Section 60, sub 1, and saying that judgment debts are funds because they fall within that definition, how, with respect, could it possibly prevent the court from undertaking the same interpretive exercise in relation to the remainder of Regulation 12, for example, as to what making available means? And the very fact that my learned friend felt compelled to accept, despite the principle of legality, that judgment debts are funds, shows, we respectfully submit, that judgment debts are made available to the designated person when a judgment debt is entered, because, my lords, the words making available are at least as clear as the word funds. Your lordships will also have in mind that there is European authority that the words making available are to be construed broadly, and that is the Mollendorf case, paragraph 51. I'm not going to take you to that, but it's volume 11 on your court's bundle, tab 58, page 3510. Fifthly, to the extent that it is my learned friend's case, as I think it is, that what the principle of legality requires is an express provision stating that the entry of judgment is prohibited, that is with respect wrong. My lords, I say that this appears to be my learned friend's case because he suggested more than once that what is required is specific wording in Samla that mandates a stay or prohibits the entry of judgment. For example, for your lordship's notes, day 2, page 167, lines 1 to 3. Lords, the authority my learned friend cited for that proposition was the Witham case, that's Mr. Justice Law's decision, in which Mr. Justice Law said that he did not think anything short of express words would do. But with respect to my learned friends, that observation of Mr. Justice Law's is no longer good law. There is Supreme Court and House of Lords authority for the proposition that if Parliament, either expressly or clearly, but without express wording, has authorised the restriction of a fundamental common law right, then any presumption that Parliament did not intend to do this, which is, after all, what the principle of legality is, a presumption, interpretive presumption, is rebutted. Can I just take your lordship back to the article by Mr. Sales, which cites the relevant House of Lords authority at this point?
It's unison amongst others, isn't it?
It's unison among others.
In unison.
Indeed, but there are other authorities. Perhaps I can just give you a reference, because it is primarily the unison case. Can I also give your lordships a reference? Unison's tab 77, page 4251 and 4253. There is also a case which Lord Sales refers to, called the Gillen case. It's a speech by Lord Bingham, and we put it in your supplemental bundle. I think it's second last tab, if I can just give you the reference to that. Paragraphs 13 to 15, internal pages 338 and 339.
13 to 15, you say.
13 to 15. And if I can just give your lordships the reference in Lord Sales, Mr. Sales' article, just so that you can see what he says about this. It's AB, tab 108, I'm not sure which bundle that is, 4986. It's the last paragraph on the page, beginning with the words, as to the second issue. Your lordship will see the points that I'll make there. It's So, my lords, with respect to my learned friend, his case on Regulation 12, in the end, we say, depends entirely on his argument as to whether the court is a person. Because the language of Regulation 12 is, we say, so clear, or at least sufficiently clear, that it must follow, even with recourse to the principle of legality, that the entry of a judgment debt is unlawful. Now, can I then move on to the question of whether the court is a person? My lords, the starting point on this issue we submit is that whatever the position of the court, it would be nothing short of bizarre if the regulations did not also apply to the executive. I have in mind my Lord Justice Newey's question to my learned friend about whether it would be open to the Chancellor of the Exchequer to pay Iran whatever he chooses to pay, on the footing that the Chancellor of the Exchequer, acting in a representative capacity or as an emanation of the Crown, is not caught by the sanctions. And although my learned friend said that he did not have a case on that, he was, I think, in the end constrained to agree that it would be very odd if this were the position. And that, for your Lordship's note, is day 3, page 141, lines 6 to 25. Secondly, and following on from the first point, the learned friend's case, therefore, necessarily involves the proposition that the regulations apply to government ministers and civil servants, but not to the court. But there is, with respect, no linguistic basis whatever in section 9.5 of SAMPA, or in the regulations, or in anything else, for treating the Treasury or the Chancellor of the Exchequer as a person, while the court or the individual judge is not. Thirdly, I'm going too fast or too slow, please say so. I'm trying to get through a fair amount, but I'm conscious that I'm pushing through a little bit quickly. Thirdly, in an apparent attempt to overcome this difficulty, my learned friend at one point appeared to suggest that the judiciary does not form part of the Crown. That, for your Lordship's note, was day 3, page 149, lines 11 to 15. My lords, that is of course completely contrary to the case my learned friend advances at paragraph 61 of his skeleton. That's page 111 of the Core Bible. And it is also completely contrary to his submission at day 3, page 144, line 11, that the court is an emanation of the Crown, which were my learned friend's words. My lords, if it really were the case, which we say it is not, that the court is not an emanation of the Crown, then of course the presumption against Crown application, on which my learned friend relies, would not apply to the court. And my lords, if the presumption is not available, then whether the court or an individual judge is covered or not falls to be answered solely by reference to section 9.5 and the EU background, in which event we respectfully submit the answer is obvious. Fourth, the learned friend did not, I think, at any stage address our submission that there is no basis whatever for saying that private arbitrators are not persons for the purposes of section 9.5 of the Act. So we don't know what my learned friend says about that beyond his bootstraps argument that arbitrators are not persons because the court is not a person, which is the way it's put in his skeleton. But if, as we submit, arbitrators are persons, then my learned friend's case would not only introduce a distinction between government ministers and the courts, on the one hand, but also between the courts and private arbitrators on the other. Finally, my lords, assuming that the court is part of the Crown, my learned friend's case, as I think he accepts, at least on this hypothesis, means that the law has changed dramatically after Brexit, because it is common ground that the Crown was bound by sanctions under the pre-Brexit regulations. But on my learned friend's case, no longer bound since Brexit. And as your lordships will appreciate, that is obviously inconsistent with my learned friend's general continuity thesis on which he relies. Your lordships may recall that my learned friend suggested two answers to that. The first was to suggest that the pre-Brexit regulations applied only to the Crown in virtue of the executive. But as your lordships will recall, Regulation 17 of the pre-Brexit regulations, which I took you to, doesn't say that. It simply says that the Crown is bound. The learned friend's second point was that whilst this might, as he put it, be, as he described it, as a wrinkle in the continuity argument, again, his language, it is absolutely clear, the learned friend's words, that a change was intended as far as the Crown is concerned. That's what he said at day 3, page 150, lines 8 to 16. My lords, the only basis for saying that this is absolutely clear is, of course, that there was before Brexit a provision that stated that the Crown was bound, which on the learned friend's case, at any rate, has been dropped after Brexit. We don't accept that for the reasons I explained in my submissions, having regard to section 52, viewed against the background of the European backdrop. That's my learned friend's case. It's been dropped after Brexit. As your lordships will have observed, what my learned friend didn't explain is why this particular change is to be regarded as an intentional change, whereas the decision to drop Article 72C, on which my learned friend so relies, or Article 11, should not be regarded as an intentional change. And cannot we respectfully submit have it both ways? Now, for all of those reasons, my lord, we submit that the court plainly is a person. Your lordships also have my submission, or our submission, that this is implicit also, perhaps explicit, in the decision of the Court of Appeal in R&R, which my learned friend, with respect, didn't really grapple with in relation to this point. And my lords, if it is right that the court is a person, your lordships have our submission that there really is nothing left in my learned friend's case about Regulation 12, which in truth hinges on this point. Can I turn next to the principle of legality, which obviously loomed large in my learned friend's submissions? I've already addressed your lordships as to why we say that the principle of legality, even if engaged, perhaps I can just make this point. I'm going to come on to the principle of legality. But if, and I've just addressed the point about the Crown. Now, the learned friend relies on the presumption against Crown application. If your lordships decide that the Crown does include the courts, and that the Crown, the presumption against Crown application is rebutted, you have then decided that these regulations and SAMBA intends to bind the court. And the question your lordships will ask yourself as we deal with the principle of legality is what is left at that point for the principle of legality? Your lordships having already concluded that the court is bound, it having been intentionally part of the Crown, including the Crown, and the presumption against Crown application having been rebutted. So we've already dealt with the presumption against application. What left is there, we say, about the principle of legality? Just addressing principle of legality separately, though, I've already addressed your lordships about why we say that the principle of legality, even if it is engaged, is irrelevant, since there is, on our case, clear parliamentary authorization for the prohibition on the entry of judgment. That, we say, flows from Regulation 12, reading the court, reading person as if it includes the court. But again, and with respect, no other viable meaning has been suggested. But again, as I've already submitted to your lordships, we only get into that if the principle is engaged in the first place. Can I address 3 points my learned friend made? The first concerned the so-called Peconic point, which derives from the legislative history of the 2018 Act and the regulations. Now, my learned friend sought to meet this point by relying on Article 47 of the EU Charter, which he says is similar to the common law principle of legality. And that, for your Lordship's notes, was at day 3, page 12, lines 1 to 8. We don't, with respect, accept that Article 47 provides my learned friend with the assistance he wants. I would just note Article 47, so far as we can tell, is subject also to Article 52, which introduces the same qualifications in Article 47 that there are in Article 6. That's to say, it doesn't matter if there's an infringement, as long as it's justified, which means you have to have regard to proportionality and legitimacy. And in that context, I would just note that my learned friend said absolutely nothing about my submissions as to why, in the context of Article 6 and sanctions, cases like RT France indicate that the European Court is satisfied that sanctions are not disproportionate and indeed a legitimate response to the problems with which they are dealing, such that even if there was an infringement, you wouldn't have to read down for Article 6 purposes. The learned friend didn't address that at all.
Are Articles 47 and 52 somewhere in the bundles? I mean, I'd have no trouble finding them if they're
I'm not sure they are. Can we provide them after the hearing, my lord? I think Article 47 is available somewhere, but we did have a quick look at them. I don't think they are in the bundles. But we have got them ready. Perhaps we can have them passed up at some point. Now, as I say, my lord, we don't accept that this actually matters at all, and perhaps I can explain why. Because what, with respect to my learned friend's argument, overlooks in making the submission is that the predecessor to the regulations is not merely EU law, but also UN resolutions, and in particular, UN Resolution 1267, dated the 15th of October 1999, which your Lordships will have at tab 1 of your first bundle. Can I just invite your Lordships to go to that? Lordships have that, and you go over to page 2. Paragraph 4. The Lordships look at paragraph 4b. The Lordships will see the familiar language of freezing funds and other financial resources owned or controlled by designated persons, and making available funds and financial resources. That's all in 4b. My lords, leaving aside for the moment any English legislation or EU regulation, and looking at just at the word funds, economic resources making available in UN resolutions, the common law principle of legality is, we would respectfully suggest, obviously not relevant, because the principle depends for its existence on constitutional arrangements that are distinctive to the UK, such as parliamentary sovereignty. My lords, if that is correct, this point about legislative history gives rise to 2 separate questions. First, were the words funds, economic resources, and making available in the 2018 Act intended to bear the same meaning that they had under the predecessor UN resolutions and EU regulations? That's the first question. Were they intended to bear the same meaning as under the EU resolutions and UN resolutions and EU regulations? And secondly, and if so, and if the entry of judgment was unlawful under the predecessor regulations, can the common law principle of legality produce a different result under this UK legislation? It is, we would respectfully suggest, important not to conflate those two questions. In relation to the first question, were the words funds, economic resources making available intended to bear the same meaning that they had under the predecessor regulations and resolutions? The answer we would suggest, and I'm not sure that this is in dispute, because this is the continuity point, is yes. As if there were not the position, the learned friends would not be running a continuity point. Parliament did not invent these terms in 2018, and there is no indication whatsoever that it meant, by using them, something different to what they meant under the predecessor regimes. So having answered the first question, one then gets to the second question, which my Lord Justice Newey put to my learned friend. If under the predecessor instruments the entry of judgment was unlawful, can the principle of legality produce a different result under the 2018 Act? And we respectfully submit that it plainly cannot. And we say that because that would involve using the principle of legality to do exactly the opposite of what Parliament intended, namely to give these phrases the same meaning, whatever that was. So having decided it was Parliament's intention to have continuity, the principle of legality plainly cannot produce a different answer, because that would involve doing exactly the opposite of what Parliament intended. Now, my learned friend, I think, suggested two answers to this, when the point was raised by my Lord Justice Newey. The first was to say that the UK legislature is enacting UK legislation, since this is what the learned judge said as well. The UK legislature is enacting UK legislation, which, in my learned friend's words, these were his words, the Constitution requires to comply with the rule of law unless Parliament has expressed on its face that they want to make an inroad. That was at day 3, page 12, lines 9 to 24. Now, your lordships have my submission that this, in fact, misstates the constitutional principle, which does not require a provision that on its face takes away the relevant right, so long as this is done clearly. But, my lords, the more fundamental difficulty with my learned friend's submission, we would respectfully submit, is that it overlooks the fact that the principle of legality is a rule of construction, a presumption about Parliament's intention, not a rule of law with which Parliament must comply. And, my lords, to presume that Parliament intended something that is the opposite of what we know it intended, namely to give these phrases the same meaning that they had under predecessor instruments, is with respect illogical. So we say my learned friend's first point doesn't work. My learned friend's second point was the suggestion that Parliament would need to be shown in 2018 to have known that the entry of judgment was prohibited under EU law and the UN resolutions. That is what he said at day 3, page 13, lines 20 to 25. My lords, with respect, the position is in fact exactly the opposite. If Parliament intended to continue the UN and EU regimes in all material respects, then that is what Parliament intended, for better or for worse. Whether Parliament appreciated every single implication of continuing those regimes is neither here nor there, because it is the fact of continuity that is determinative of Parliament's intention. So, my lords, on the hypothesis that the words funds, economic resources, dealing and making available in the 2018 Act were intended to bear the same meaning that they had in predecessor UN resolutions and EU regulations, we submit that interpreting them by reference to the principle of legality would undermine rather than promote Parliament's intention. So that was one of the four reasons we gave as to why the principle of legality was not engaged. Another reason, Your Lordships will recall, was the Belhage point. And this point, as Your Lordships again will recall, derives from Lord Sumption's observation in Belhage that the principle of legality is displaced if it is clear on the face of the legislation that Parliament does intend to curtail certain fundamental common law rights. My Lords, I should emphasise at the outset that this means only, that's to say when the Belhage point arises, it means only that the principle of legality is displaced. In other words, that there is no presumption in either direction. It does not mean, and we have never suggested it meant, that because fundamental right X has clearly been curtailed, it follows that there was an intention also to curtail fundamental right Y. That, I'm afraid, was again a straw man set up by my learned friend at day 3, page 6, lines 14 to 25. It's never been our case. My Lords, beyond that straw man point, my learned friend also sought to distinguish Belhage on the basis that the legislation there was explicitly designed to make inroads into the principle of open justice. And my Lords, so it was. But as Your Lordships may recall, it did say only in relation to the language of the statute was relevant civil proceedings. It said nothing, one way or the other, about judicial review concerning the decision of a prosecutor, which was the issue in that case. But despite the absence of express wording dealing with that, Lord Sumption said that the principle of legality was displaced. That's all, displaced. It was a matter of looking at the ordinary language. Now, Your Lordships will recall that there was another aspect of the Belhage point that we identified, which is that Parliament, in the 2018 Act, intended not only to restrict the common law right of property, which is obvious by the freezing provisions, but also the right of access to the court to challenge designation decisions. And Your Lordships will recall that I took Your Lordships to the decision of, I'm not sure I did take Your Lordships, I referred Your Lordships to the decision of Mr. Justice Garnham in the Yusuf case as authority for this proposition. And that was volume 13 of the bundles, tab 78, page 4265. Now, Your Lordships may recall, or Your Lordships will see in due course, you'll recall that my learned friend sought to distinguish Yusuf by suggesting that that case was concerned with the right of access to justice to challenge designation decisions, which in my learned friend's words, these were his words, tells you nothing to establish that Parliament also might have intended to abrogate the right to civil justice. That's what he said at day 3, page 10, lines 4 to 7. My Lords, there are with respect to two problems with that. The first is that it entirely misses the point. We don't say that Your Lordship should infer from the restrictions on the right to challenge designation decisions by judicial review that the entry of judgment on civil claims is prohibited. Don't show that it shows any intention that it be prohibited. That is again the straw man. We say merely, much less ambitiously, that there is no presumption that they are not restricted. That's the Belhage point. And where Parliament has expressly restricted the right of access to justice in one respect, which is what it's done here, or in here, it is, we say, for the reasons Lord Sumption gave, wrong to presume that Parliament did or did not intend to restrict it in some other respect. The question falls to be answered without presumptions in either direction. My Lords, the second problem with my learned friend's submission is there is actually no express provision in SAMLA that takes away the right to challenge designation decisions by judicial reviews. So again, there is nothing express in SAMLA which says that. What led Mr. Justice Garnham to that conclusion is the fact that Section 38 of SAMLA, simply by setting up a statutory mechanism, excluded by implication other mechanisms for challenging designation decisions, for example, ordinary judicial review. That, for your Lordship's note, is at paragraph 61 and 62 of Garnham, volume 13, tab 78, page 4279, letters F and G. And so it is inconsistent with my learned friend's contention that the right of access to justice cannot be taken away except by a specific provision on the face of the legislation. I don't know whether your Lordships want to take a break.
Yes.
Right. Then now would be a good time.
Okay.
Actually, no, it's perfect. Because your tones people. Mine is. You make that way too. You know, yeah. You're supposed to wear socks all the time, and your feet are cold. If you don't, it feel like it's really bad for you. So make sure you wear socks if it's cold. Yes, it's the summer. I mean, all the time I have like, what's it says? I wear like 2 layers. It's my feet go cold. I was cold here. My feet like fridge and I was like cold. And then
It's not an issue with
it's not. I think we will choose it.
Hopefully not too much longer.
Can I then turn to the submissions my learned friend made about the EU regulation, obviously Article 72C, and some related points, including Section 44 of SABLA and R&R. And the first and perhaps main point my learned friend made concerned Article 72C. It is, my lords, we respectfully submit, important to understand the structure of the Article 72C argument that is advanced by my learned friend. If, as we contend, the entry of judgment is prohibited under the EU regulation, that is, as your lordships appreciate, obviously not because of Article 72C, but because of Articles 2.1 and 2.2, which correspond to Regulations 11 and 12 of the current UK regulations. The significance of Article 72C, of course, is that my learned friend seeks to use it as a hook to alter what would otherwise be the meaning of Article 2.1 and 2.2, and therefore Regulation 11 and 12. And he does that by saying that it is a necessary implication of Article 72C that the entry of judgment is not unlawful, whatever the wording of Article 2.1 and 2.2 might otherwise suggest. So, my lords, the question for your lordships is whether Article 72C is indeed the source of such an implication, because if it is not, then one would simply construe Articles 2.1 and 2.2 in the usual way. My lords, an immediate difficulty in the submission that 72C is the source of such an implication is what we've called a timing point, the timing point. And the point is this: Articles 2.1 and 2.2 and Regulations 11 and 12 have, as I've already noted, their origins in United Nations Security Council Resolution 1267 of October 1999. That is a point the learned judge made at paragraph 16 of the judgment, and I don't understand that to be an issue. Your lordships have that resolution, we've just looked at it at tab 1 of volume 1, and as your lordships will recall, it contained the prohibition on freezing funds and economic resources, then called financial resources, and no making available funds and economic resources, but it did not contain the 72C exception. Over the years, as your lordships will know, the UN Security Council adopted a number of other resolutions imposing targeted sanctions on various groups. One example is UN Security Council Resolution 2140 of February 2014. Your lordship should have that in your supplemental authority. I think it's penultimate tab 13.
Tab
13 of the supplemental authorities.
tab 13. 11 tabs.
11 tabs.
Seem to have been particularly
Can I just ask, it appears they may not have made it to your lordship. You've got it. Do you have some more? sorry, they doesn't get to it. Now, if I can invite your lordship, sorry, I'll wait. If your lordships have it, and if you can go to paragraph 11, which is on page 353. Your lordships will see that this corresponds to Articles 2.1 and 2.2 of the EU regulations and regulations 11 and 12 of the UK regulations. If your lordships then look at paragraph 13 on the following page, page 354. Your lordships will see that this exemption is the equivalent of Article 7.2b. But your lordships will find no equivalent provision corresponding to Article 7.2c. My lords, so far as we can tell, there are a number of UN resolutions and EU regulations, particularly before 2013, which contain the 7.2b exception, but not the 7.2c exception. For example, and we will provide copies of these for your lordships if you would find them helpful, EU Regulation 36 of 2012, Article 19.1b, as it originally was, before it was amended in 2013 to introduce this exemption, and Council Decision 2016-849, dated 27th of May 2016, concerning sanctions against North Korea, Article 27.5b. In the UN resolutions and the EU regulations, which have the basic provisions on dealing and making available, that is to say the equivalent of regulations 11 and 12, but do not have the equivalent of Article 7.2c, plainly 7.2c cannot be the source of any implication that could change the meaning of the basic prohibition, because it is not there. So my learned friend's case on 7.2c depends upon the proposition that the meaning of the basic provision, although expressed in exactly the same language, changes depending on whether it is accompanied by 7.2c or not. If it is accompanied by 7.2c, then my learned friend says that by necessary implication, that means that the basic prohibition does not prevent the entry of judgment. But if it is not accompanied by 7.2c, then it does not have that effect. And that, in our respectful submission, my lords, is very unlikely to be correct. Indeed, my learned friend goes further, because he says that even in instruments in which it is not accompanied by Article 7.2c, the meaning of the basic prohibition changes, because in an earlier instrument, it was accompanied by it. But one might ask this: now that 7.2c has disappeared again, and everyone agrees that it has, why is the meaning of the basic underlying prohibition not the same as it was during the period before 7.2c was first introduced? The language of the basic underlying prohibition has remained the same throughout. My lords, that's what we call the timing point of this. Now, in addition to that timing point, we say that there are three other reasons why 7.2c does not give rise to the implication for which my learned friend contends. First, and this is a point that I made in opening, it would enable the temporal restriction in 7.2b to be circumvented by allowing a designated person to turn a post-designation contractual right, which cannot be enforced, into a post-designation judgment debt, which then can be enforced. My learned friend's answer to this was to suggest that the EU legislature did not think there was anything objectionable in the enforcement either of voluntary pre-designation obligations or of coerced post-designation obligations. And that is what he said at day 3, page 39, lines 13 to 17. But my lords, the assumption at this stage of the analysis is that the draftsman did indeed wish to prohibit the voluntary satisfaction of post-designation obligations. For example, a contract entered into by a designated person to be paid a sum of money. That is why 7.2b is drafted in the way that it is. The draftsman evidently wished to prohibit that, even where the proceeds are paid into a frozen account. That is common ground, because my learned friend accepts in relation to 7.2b, as it expressly says, it is confined to pre-designation obligations. But if, my lords, the draftsman wished to prohibit that, there can be no reason why he was content for that obligation to be satisfied, simply because the designated person sued upon it and obtained a judgment. No rational sanctions objective, we would suggest, is served by permitting the latter but prohibiting the former. Because
might the distinction be that in one case, in the coerced payment, there has been an adjudication, and therefore you're not at risk of someone purporting to make a voluntary discharge of an obligation which is not subject to any kind of oversight.
Well, that with respect is a justification that may be put forth, but in our respectful submission, that is a bootstraps argument. The idea being that the draftsman would wish to treat coerced payments differently, that is to say where the court has adjudicated them, because it involves the contention that the EU legislature doesn't wish to interfere with court proceedings. But that is the very point which we have to decide. So it's saying that's the reason, therefore that explains the prohibition, therefore it proves that that it's intended to allow post-designation judgments. In our respectful submission, that is a bootstraps argument, which in a sense, however way you look at it, it's not a rational approach to the sanctions regulations, because one way or the other, the sanctioned person is getting money post-designation, whether coerced or not coerced. Now, my lord, we respectfully submit it, and again, it's important to understand how this arises. It's all about an implication. One can look at it, it doesn't say you can get a judgment. One is trying to work out, well, it allows satisfaction, what does it entail, what does it mean, what is implied in that? And the argument, as I say, is the timing point means it's very difficult to see how this works. But the other point is that if you imply this, it produces an inconsistency, it appears to produce an inconsistency with 7.2b. All I'm trying to do, all I need to do, is to say this implication doesn't necessarily arise. And therefore doesn't, in a sense, carve something out of Articles 2.1 and 2b. In our respectful submission, the possibility of circumvention, the possibility that I've identified, i.e. you can't pay a post-designation debt, but you then say, okay, well, don't pay it, I'll tell you what, I'll sue you, and then you'll pay it, and then we are exactly where we would have been if it had been a pre-designation debt. And we respectfully submit that that possibility of circumvention is at least a factor that militates against the implication on which my learned friend's argument depends. Secondly,
But it's not circumvention. It's because under the EU regime, the money gets paid into the frozen account.
with respect, it is circumvention, because even if it is being paid into a frozen account, 7.2b limits your ability to do that, where it's you're paying an obligation to pre-designation debts. And the implication of that is that post-designation debts could not be paid even into a frozen account. But what this is enabling you to do is to take a post-designation debt and say, look, don't pay, I'll sue you.
That may be the effect of what is in the regulation, but the fact of the matter is that C does not contain the same limitation as B.
Your Lordship's right, that may be
You were
within-
right, it contained the same limitation as B.
But my lord, the very question is what is it that the regulation does provide? It certainly doesn't say you can get a judgment debt. The attempt, that is, the argument involves implying from what is at 7.2 that you are entitled to get a post-designation judgment debt in circumstances where, in my respectful submission, it plainly provides an avenue for circumvention in relation to debt obligations which are post-designation. Because you simply bring proceedings, get a judgment, and hey presto, you're no longer enforcing a debt obligation, post-designation, which you cannot do. You're enforcing a judgment debt, which in my learned friend's case you can do. It drives a coach and horses through.
The judicial proceedings referred to, by definition, well, not necessarily, I mean, I suppose there might be circumstances in which you add money to the account which is due under a judgment that's delivered before the relevant sanction comes into effect. The chances are most of them are going to be post the relevant sanction coming into effect.
Well, maybe
So
not.
not apply to the addition to frozen accounts of payments due under judicial decisions.
My lord, it rather depends on what we think 7.2c does entail and what it
Judicial
does imply.
decisions don't just sort of appear, they don't pop out of nowhere, Mr.
Well, and I accept that. I'm not suggesting that this does not have any purpose and scope. It certainly can apply to pre-designation judgments. The question is whether you read into that it can apply to post-designation judgments, because if you do, you are undermining the limitation in 7.2b, or at least you're creating a circumvention route. My lords, we say that even if we're wrong both about the timing point and the circumvention point, there remains the fact that 7.2c was quite deliberately not transposed into the UK regulations. Your Lordships have my submission that Regulation 58.5 cannot possibly be transposing Regulation 7.2c, it's 7.2b. Indeed, the contention that Regulation 58.5 does this, that's to say that it transposes 7.2c, is contrary to the decision in the Modsaf case, a point I made in opening, but which my learned friend didn't address. Your Lordships note that was transcript A1, page 117, lines 5 to 10. And if that is right, my lords, the UK regulations, that is to say, if it has deliberately not been transposed, 7.2c, the UK regulations are exactly like the UN resolutions 1267 of 1999 or UN resolution 2140, 2014, which have the basic prohibition in what is now Regulation 11 and 12, but not the 7.2c exemption. And this is a further, and we would respectfully submit, compelling reason why the meaning of those basic prohibitions should not be altered by an implication derived from a provision that is not there. That is all I was going to say about Article 7. Can you Lordships bear with me? Now, can I then move on to say something about Section 44 of SAMRA?
Yeah.
The learned friend suggested was a source of another implication that the entry of judgment is permitted. And there are, we respectfully submit, two problems with this. The first is that Section 44, like Article 11 of the EU regulations, is a prohibition and not a permission. And the fact that a particular claim is not prohibited by Section 44 does not mean that it is permitted, but only that it is not prohibited by Section 44. Secondly, and in a sense this is to put the same point another way, Section 44, as I think my Lord Justice Newey put to my learned friend, does not operate only when sanctions are in force. It rather permanently extinguishes claims that fall within it. even after the designated person ceases to be designated. And that being so, my lords, it does not with respect tell one anything about whether the entry of judgment is permitted any more than does Article 11.
Mm-hmm.
I should, in this context, just pick up another point my learned friend made, this time about Article 11.2 of the regulations. Sorry, the EU regulations. Just to turn that up, we'll call this page 21 behind tab 2. When you get Article 11, Article 11.2 is on page 22. And as your lordship sees, this is the provision which says that the designated person bears the burden of proving that the claim does not fall within Article 11. As your lordships will recall, if the designated person discharges that burden, then the claim is not prohibited by Article 11. My lords, respectfully submit that it certainly does not follow that just because the designated person discharges the burden, so the claim is not prohibited by Article 11, it doesn't follow that the claim is permitted, because it could be prohibited by some other provision, such as Articles 2.1 or 2.2. Now, the learned friend also referred to Article 5.1a of the EU regulations. That's at page 13, tab that we're in. As your lordships will recall, that permitted a license to be given, so it's all about a license, and it permitted a license to be given for both pre- and post-designation judgments. I'm not sure that this matters for the purposes of ground 1, because in fact Article 5.1a, as it expressly says, is concerned with judgments against, not judgments for, designated persons. So in one sense it has absolutely nothing whatsoever to do or say about the problem that we're dealing with. I mention it, my lords, because my Lord the Chancellor and indeed my Lord Justice Newey asked my learned friend whether the UK regulations departed from that. The learned friend's answer wasn't entirely clear. What he said was that they depart from it, and I think he said in form, but apparently not in substance. That submission was based only, with respect, on the assertion that it is not contrary to any sanctions objective to permit a designated person's funds to be used to satisfy a judgment, since, as he was putting it, this would subtract from a designated person's assets rather than add to it. So his point was, because it's detracting from assets rather than adding to it, in substance it was working exactly the same way, even if in form it was different. That was at day 3, page 36, line 20 to page 37, line 4. Now, your lordships have our submission, which my learned friend did not address, that it is in fact no part of the sanctions, of the objective of the sanctions regime, to subtract from a designated person's assets any more than it is to add to them. The purpose of the regime is to freeze those assets so that there is neither addition nor subtraction, save as is permitted by the regulations. So it is wrong, we respectfully submit, to construe the regulations on the assumption that something that reduces the designated person's assets is likely to be okay. With respect, that is simply a false premise completely. The reality, my lords, just going back to Article 5.1a, is that the UK made a conscious decision, reflected in the language of the corresponding provision, not to permit frozen funds to be used to satisfy a post-designation judgment. And the fact that it is deliberate is clear from the FCO policy note, which, for your Lordship's notes, is at tab 113 of the bundle, page 5133, paragraph 17. They deliberately say we're changing this, and indeed they give a reason why. Finally, my lords, can I quickly just deal, finally under this heading, can I quickly just deal with what my learned friend said about R and R? Now, the first point to make, again, is that R and R is not a case about whether a judgment may be entered in favour of a designated person. So again, it is not a case which is directly relevant to the matter that your lordships have to decide. And indeed, there was no argument about that point. Secondly, the court's conclusion that judgment may be entered against designated persons derived from Article 5.1a, the article we've just been looking at, which permitted post-designation judgments to be licensed. And that is at paragraph 25 of Lady Justice Arden's judgment, to which my learned friend took your lordships. But my lords, the UK regulations produced post-Brexit, and I've just made this point, expressly confine the exception we saw in Article 5.1a to judgments against designated persons that predate designation. Your lordships will recall that is Schedule 5, paragraph 6. I'm sure your lordships recall that.
Yeah.
The equivalent of Article 5.1a is not, I think as my learned friend suggested, Regulation 58.5, but Schedule 5, paragraph 6, which, as I say, is limited to pre-designation judgments. So again, the whole premise of the reasoning by Lady Justice Arden is predicated on a wholly different provision, which is no longer the same. So thirdly, and leaving aside the UK regulation for a moment, my learned friends also sought to deploy R&R as authority in relation to Article 7.2c, at least by analogy, by suggesting that the same logic applies to that as applies to Article 5.1a. My lords, there is, we say, an important distinction between the two. The implication the Court of Appeal derived from Article 5.1a was not contrary to any other provision of the regulations, and in particular Articles 2.1 and 2.2, because the payment by a designated person of a judgment against him does not involve making of funds available to anyone. It wasn't contrary to Article 2.1 and 2.2 to make a payment, to find a payment could be made by a designated person. It wasn't caught by Articles 2.1 and 2.2. By contrast, the implication which my learned friend contends should be derived from Article 7.2c is entirely contrary to what would otherwise be the meaning of Articles 2.1 and 2.2. And indeed, the two cannot stand together unless a proviso is read into 2.1 and 2.2, excluding the entry of judgment. So, my lords, R&R does not assist my learned friends. In short, first, the point now before your lordships didn't arise. Secondly, it wasn't argued. Thirdly, the passages on which my learned friend relies concern provisions that have been taken out of the UK regulations. And fourth, they don't support his construction even of the provisions in the EU regulations in question. Can I then say something very briefly about Regulation 11? I've tended to stay away from Regulation 11 simply because the position is very much more straightforward in relation to Regulation 12. There's one point I need to pick up, a couple of points I do want to pick up about Regulation 11, because they are relevant, or may be relevant, to the issue of workaround, which I also need to deal with. And my lords, in relation to regulation, I was just going to make two short points. I'm not going to get into some of the other more complicated points, because in my respectful submission, they're probably unnecessary for your lordship's decision. Two short points are these. First, even on the assumption that a cause of action for damages is only an economic resource, as my learned friend contends, the question is whether there is a dealing in it when the court enters judgment. The only point the learned friend made about this is that there is no exchange, because as we understood his submission or contention, so there was no exchange because there is no transfer of value between the claimant and the court. I think it was an exchange with my Lord Justice Popplewell. In the learned friend's words, Regulation 11.5b applies only, and these were his words, only if both parties are left with what the other one had or doesn't need anymore. That's day 3, page 119, lines 2 to 10. And my lords, we respectfully submit that it is not possible to reconcile the limitation that my learned friend wishes to read into Regulation 11.5b with the example expressly given in 11.5b, namely the pledge of an economic resource, say a house as security. And your lordships may just want to glance at that. Page 917. Your lordship sees this, the example, a person deals with economic resources if the person uses the economic resource in exchange for funds, goods or services, and then it says whether by pledging them as security or otherwise. So we say that the limitation my learned friend wishes to read into Regulation 11.5b with the, is inconsistent with the example expressly given in it, namely the pledge of an economic resource, say a house as security. Now, just to illustrate that,
Yes, sorry, go on.
assume that someone provides land as security to obtain a loan from a bank, or that they lease or license the land out to someone who pays them rent or a fee. In those examples, they have used the land to obtain funds in the form of the loan, the rent, or the license fee. They have obtained some right from the owner, but they have not, in my learned friend's words, obtained the thing the owner had or doesn't need anymore. Indeed, the licensee does not even obtain any interest in the land, merely permission to use it. So a designated person who comes to the court, invites the court to enter judgment on its cause of action, and obtains a money judgment as a result, is plainly using that cause of action in exchange for the fund that is the money judgment. I seem to have lost the page of my notes. Second point I was going to make, my lords, is this.
Sorry, just thinking one moment around that. He loses the cause of action, but who gets anything?
Well, no one needs to get the cause of action. He's exchanged the cause of action for something. But it doesn't mean that another person... So let's say I have a coupon to use for something, which someone then tears up, exchange for something else, for, I don't know, money. No one in the end gets the coupon, it gets thrown away.
I don't know about that, because with an ordinary, say you have a coupon from a shop or a petrol station or something, until the coupon is handed over, the holder of the coupon has a right against the petrol station or the shop. And that goes.
That goes.
The shop or the petrol station is better off. Because in accounting terms, it no longer has the liability in respect to the coupon.
Yeah. We'll take the example of a license to use land for a fee, for a food stall. What is it that goes? I grant a license. I'm not giving, an exchange I get a fee. I haven't actually lost, the person who uses the land, who has the ability to use the land, pays me a fee. But what have I given up?
I mean, in strict landlord terms, maybe there's no interest in land, but in non-strict landlord terms, a right in respect to the land has passed or been created. I mean, you've lost the ability to use the land yourself, you get a fee.
Well, then just go back to the pledging the pledging example. I have something which I use to get something from the court, and I mean, your lordship says, well, how is it? It says it uses the economic resource in exchange. So, if I get a judgment and it merges into the judgment, sorry, the cause of action merges into the judgment, I've exchanged what I had, which was a cause of action, for something else, for a fund, because the judgment, maybe the cause of action is merged in the judgment, I now have a fund. I've used or exchanged my cause of action for that fund.
Yes, that's what you get out of the exchange. You've lost one thing and gained another. The counterparty, I mean, the court hasn't lost or gained anything.
Well, that may be so, but I'm not clear why the court has to have gained anything. What matters here is the designated person is getting something. The designated person is using is in effect exchanging something that is no longer in his hands. What is in his hands instead is the fund, and therefore what he has done is to exchange the cause of action, which was in his hands, for a fund. I mean, in that simple way of describing it, in my respectful submission, it plainly falls within 11.5b.
Yeah.
I'm sorry I laboured that point. I think there was a second, unless your lordship wants to. Okay.
Absolutely.
I knew I should have stayed away from Regulation 11. The second point I was going to make about Regulation 11 is this. If a cause of action is a fund, and we haven't, my first argument was that my first point was on the basis that the cause of action is not a fund, but a economic resource which is exchanging for a fund. If a cause of action is a fund, as we contend it is, then your lordships have our submission on why there is a dealing when judgment is entered for the claimant. But there would be a dealing even if it were to enter a declaratory judgment. Because at that point, the court will have confirmed that there is a valid cause of action, which my learned friend, which is a point my learned friend came close to accepting, meant it was a fund. In other words, the learned friend drew this distinction at some point of the argument, I'm not saying it was there at the end, between an arguable cause of action, which he said was definitely not a fund, but was an economic resource, and a valid cause of action, in other words, a cause of action which was actually a winning cause of action, which he came close to accepting was a fund. Now, if a cause of action is a fund,
By which, for the purposes of this argument, you mean an arguable claim as opposed to a valid cause of action.
Exactly.
That's what you mean by it.
exactly, we say there'd be a dealing even if you were to enter into a declaratory judgment, because at that point, the cause of action will have confirmed, the court will have confirmed that there is a valid cause of action, which, as I say, which would have changed the value of the cause of action, which would have increased.
Oh,
Wait,
sorry,
the character.
Sorry, that must mean your answer wasn't
My
the one you
last
gave
answer to your
to
lordship was not. Let's say you have a cause of action which is not a fund.
So can we just define what you mean in this submission by cause of action? Do you, on the one hand, mean an arguable cause of action, or do you, on the other,
For the
mean
purpose
a
of this
valid
argument.
cause of action?
For
For
the
this argument.
For the purpose of this argument, arguable cause of action
That's what it is.
is an economic resource. Let's assume it's an economic resource.
Yeah.
when a court confirms that it is a valid cause of action, then in our respectful submission, what is happening is you are exchanging an economic resource for a fund. In a sense, that's to go back to the argument or the discussion I was just having with my Lord Justice Newey. If, on the other hand, a cause of action is a fund, which is our primary position,
Still meaning arguable cause of action.
arguable cause of action, we say there would be a dealing, even if the court were to enter into a declaratory judgment, because at that point, the court, well, I wonder if I have to say, I'm going to say arguable first, because at that point, it's arguable until you give a declaratory judgment. At that point, you're saying it's not an arguable cause of action, it's a valid cause of action. So what you have done by giving a declaratory judgment is to change the character of the arguable cause of action by saying it's a valid cause of action.
Yes, but you're treating the fund as being the arguable cause of action.
Indeed.
And,
So what
and
you
this
do-
this has the consequences we've discussed of the same would be true of dismissing a summary judgment application, raising an eyebrow, commenting in interlocutory proceedings, etc.
If you give a,
Because that changes the value of your arguable cause of action.
not to make it a valid cause of action.
No, but still changes the value.
Still changes its
May
value.
may not change it
I accept that.
dramatically.
Maybe that it proves too much, I accept that, I accept that. Can I, however, just then, having made those regulation 11 points, I knew that was territory I was probably better off stay away from, just deal with the workaround issue. And I think take this fairly shortly, my lords.
What's this? Sorry.
Workarounds. Now, I should say at the outset that even assuming that the workarounds would not themselves infringe the sanctions regime, and I'll come to that in a moment, there is an issue as to whether it's appropriate as a matter of English common law for the court to adopt those workarounds, and whether, even if it is, it should do so in the exercise of its discretion. Those questions are, we submit, only relevant at the discretion stage, because the commercial court would need to decide whether it is an appropriate use of resources of the court and the parties, if all that you can get at the end of it is one of the workarounds, for example, a reasoned judgment without any order.
Well, if the workaround if that's how you're describing it, it's a declaratory judgment, then speaking for myself, I can't see why the commercial court would balk at that.
Well, can I just address that?
Especially given the circumstances in which the point would arise. Which is that
Well,
the
I have to
alternative
address-
is you're right about every point and
I understand.
the case gets stayed now.
I understand what your lordship's saying. There are two issues that arise. The first is whether you can do it, whether it can. The second is whether, if it can, it ought to. The ought to will be a matter of discretion.
Well,
I'm only going to address the can you.
That's right, I suspect. I mean, we might, if we're against you on this, we might say, it seems to us that one possibility is one of the workarounds, but we might also say that ultimately that's a matter for case management and the discretion of the commercial court, and remit the case
I understand that.
for those purposes.
Indeed. My lords, in my respectful submission, it is obviously appropriate for your lordships to consider whether, as a matter of law, the various workarounds can be made available, can be used. As to whether they ought to be used, that may involve a series of points and issues as to whether it's a waste of time, etc. I'm not going to take up time now. That is the matter of the discretion, and that's the distinction I'm trying to draw. I'm going to address your lordships on whether it can, in a sense, take a workaround. I keep using it. I don't mean to denigrate the significance of these. I understand those, and your lordships will want to make a decision about whether these are permitted. And we respectfully submit they are not permitted, and indeed they are prohibited by Regulation 12, by Regulation 11, and indeed by Regulation 19. Can I just address that? First, if the court were to declare, for example, that the defendant owes the designated person the sum of £5 million under a contract. That declaration would be binding on the parties, and the designated person would be able to rely on it as conclusive, for example, as giving rise to an estoppel in any foreign proceedings or in any future proceedings here seeking an order for payment in terms of the declaration. The rights created by the declaration would, we submit, plainly be a financial benefit for the designated person. Indeed, it would be like giving the designated person a post-dated cheque for £5 million. So that's a declaration that the designated person, that the defendant owes the designated person the sum of £5 million under the contract. Declaratory judgment to that effect. We say that would be a financial benefit for the designated person for all the reasons I've identified. Give them a right as against the designated person, which he could use. Now we know that I say it's like a post-dated cheque. It is still a cheque. We say that would infringe Regulation 12. That obviously requires me to say that that is a fund, creating a right as against the defendant in that way. So a right in the hands of the claimant would be a fund. The Lordships will recall that within the definition of fund, it's section 60, is it? 60 subparagraph 1. Under C is a right of set-off. So a right which you can use in litigation or to set off against something counts as a financial asset in a fund. In our respectful submission, this would be no less a financial asset than a right of set-off. In fact, it would be much more of a fund than a right of set-off.
I think your submission that a declaratory judgment creates rights may be quite heterodox.
Yes.
I think we may have had to address this question in one of the prestige cases, but my understanding has always been that the doctrine of merger doesn't apply, and one of the reasons it doesn't apply is that you're not creating any new rights, you're simply
Declaring the rights.
My point, my lord, is this: it would be the designated person would be able to rely on that as conclusive. For example, as giving rise to an estoppel. I don't think that can be controversial, and they'd be able to rely on it as giving rise to an estoppel in any foreign proceedings or in any future proceedings here, seeking an order for payment in terms of the declaration. So that
It's a right.
Yeah.
It's right. It's a right which, on this hypothesis, the claimant has, and the court is merely declaring that it has that right.
it already has that right, and the effect of declaring that it has that right is that it's not allowed to challenge it for a second time, therefore estoppel. I wouldn't call the right to rely on the declaration of rights some freestanding right.
what one is then doing is changing the character of that right. Because if
That assumes that the right is a fund. Because otherwise, the fact you may have changed its character, if it's simply a right the designated person has.
It's not results, you haven't done anything to it. The cause of action is still survives a declaratory judgment.
Well, with respect, the cause of action may have survived, but it's changed its character because it's supported by a judgment.
Well, that's the point you were on earlier on.
It's changed
I
its
thought
character.
you were on a slightly different point now, which a declaratory judgment itself creates rights.
Exactly. But it also changes, it changes the character of the cause of action, assuming that all you have is a declaration.
That's the point you were on a few minutes ago, I understand.
But the underlying, the further point is this: the underlying cause of action would become a fund. And an essential lordship's right, this is the point I was on before. But if you have an underlying cause of action, which is arguable, it's now a valid cause of action. I think the point I was on earlier was that once you've moved from an arguable cause of action to a valid cause of action, because the court has said your cause of action is valid, and in our respectful submission, it is a fund. And if that is what the court is doing, then that would infringe Regulation 12, because the rights created by the declaration would constitute a fund, and are made available to the designated person when judgment is entered. Now, secondly, and alternatively, we submit that it would infringe Regulation 11, and there are two possibilities. If the cause of action asserted by the designated person was already a fund, then of course by giving a declaratory judgment, its character or value changes, either because the claim succeeds and the value increases, or because the claim fails and the value decreases.
Can I just come back to one point I touched on a long while ago? I follow the point about character, but where does value come into this? I mean, that's not in the list of things that can be changed.
No, I mean, I can tell your Lordship that in Taruta, Mr. Justice Jack said that it was, but that may not be of great assistance to your Lordship. Paragraph 34 of Taruta. I think the point I made when your Lordship asked me that earlier is that, well, let's do this. If I have a debt for £10 and I change the value of that to £10 million, have I changed the character of the debt? And in my respectful submission, I have, just by virtue of changing what it is worth. Alternatively, what I have done is, if not changed the character, I'm just looking at the other language here, to see the wrong. Just give me one second, I'm on the wrong state regulation. I think character is probably.
It would have to be character.
I think so. So I think I was on my regulation 11 points.
Yes.
Yes.
The second way in which we say it would infringe regulation 11 is, so I've made my submission about what the position would be if it was a fund. If, on the other hand, a cause of action was previously only an economic resource, then at least at the point of the declaratory judgment being entered, the court will have decided that it is a valid cause of action, not merely an asserted cause of action. And a valid cause of action for a sum of money is, we would suggest, a fund. Since I'm repeating the same thing, but in the context of the workarounds. If that is right, the claimant has used his cause of action, previously an economic resource, to obtain a fund in the form of the cause of action with the benefit of the declaration, and that would fall within 11.5. My Lord, our third point is this. At this stage of the analysis, the hypothesis is that the entry of a judgment debt is unlawful. You only reach this point if your Lordships are with me, that a judgment debt at least is unlawful. Now, but for the sanctions regime, it is inconceivable that the court would grant a bare declaration, because doing that would not serve any purpose. The court would either dismiss the claim if it is not a good claim, or award damages if it is a good claim. And so if declaratory relief were to be given, the sole purpose of doing so would be to get around the sanctions regime. And that, with respect, could not be a legitimate reason for the court to exercise its discretion to make declarations, even leaving to one side why the court should wish to find a way to work around the sanctions regime for the ultimate benefit of the Russian state. And doing so, we respectfully submit, would therefore infringe the circumvention prohibition in Regulation 19. My learned friend asserted this morning that the Regulation 19 point was not raised below. I think he said it was raised by me for the first time. With respect, that was wrong. It was raised earlier. It was raised in front of Mr. Justice Cockerill. And I'll give your Lordships a reference to that. Day 1, that's the transcript in front of Mrs. Justice Cockerill, page 77, line 20 to page 78, line 15. Now, my Lord, the Chancellor referred this morning to R&R,
Yeah.
and I need to deal with whether what he said in that case is inconsistent with our case about circumvention. And we submit that it is not. And that is because there is an important distinction between R&R and this case. In R&R, the reason why the order of Mr. Justice Moore requiring the husband to pay the wife in Russia was not a circumvention. The reason it was not a circumvention was that even an order requiring the husband to pay in England, which was the ordinary order that would be made in the family division, would not have infringed sanctions. That was the very finding that the court made. The reason it would not have infringed sanctions was that the designated person was permitted to satisfy a post-designation judgment under Article 5.1a of the EU regulation. It was a judgment against the designated person, and the court found that the effect of Article 5.1a was to permit it. So there was nothing to circumvent. That was the reasoning for the court. I suspect that's got nothing to do with this case. Just for your Lordship's notes, the significance of Article 5.1a is mentioned both by Lady Justice Arden at paragraph 33, that's a tab 83, page 4360, and by Lord Justice Briggs at paragraph 54, it's tab 83 again, page 4366. My Lords, subject to your Lordships, that was all I was going to say.
Finishing before 4:15?
Yes.
Obviously, we're reserving our judgment. I'm going to make no promises as to when it will be available, only to say it is extremely unlikely to be available this side of a long vacation, for obvious reasons. When you get it, two things. One is it's to provide the court with any typographical and similar corrections, not to invite us to re-decide the case. And the other thing I point out is please pay close attention to the terms of the embargo. As you're aware, there have been a number of instances in the recent past where the embargo has been breached, and Chancellor Rolls in particular is very anxious that we should impress upon all parties and their legal advisors the importance of complying with the embargo. It only remains to thank all of you for the way in which the hearing has been conducted. Whoever's right or wrong, it's been extremely well argued on both sides. And thank you to all of you and to all your teams, because we appreciate that it's not just the leaders, it's all the juniors and the solicitors as well. Thank you very much.
My Lords, before you rise, I said I would hand up, well, I don't know whether I said I would hand up or not, but I've got Article 47 for you.
Yeah.
If I could just pass that.
Thank you very much.